Ena rangatira, ena mana, ena iwi tēnā koutou, tēnā koutou, tēnā koutou katoa. Ko Ngāti Whakaue te iwi, ko Clear Charters tākou ingoa. Ngā mihi nui nui kia koutou. It's fantastic to be here, and it is the greatest honour to be speaking actually after Moana Jackson, who has inspired, I think, all of us around the nation in thinking about especially issues around self-determination, and has provided the philosophical grounding, I think, for so many of us in our mahi in this area. Sorry, I'm going to have to yell at you a bit to compete. But with our mahi in this area, both practically and giving us a good reason and motivation for our work, but also to help us in our arguments when we're presenting either at home at the domestic level or at the international level. Can you hear me okay? Okay, ka pai. So I would like to talk about the declaration in the courts and the Waitangi Tribunal, but particularly pick up on this idea that was something that I talked about a lot in my PhD, was how we enhance what I call the legitimacy of the declaration. And I really want to focus on enhancing the legitimacy through our engagement with the declaration. My basic points are that the political influence of the declaration is often questioned. This morning on Watia News and speaking about this conference, the first question, as it often is, well, you know, what use is it to us? And I think that was also something that Peter Sharples was also mentioning to us. So, you know, we have to really find the influence of it, find its value, and what is that? And certainly you see that there is some resistance, and I've got another slide next, that illustrates the resistance of our government to the declaration and to really engaging and using it. But what I guess the thesis or the argument that I'm trying to present is that the legitimacy of the declaration is what really matters, and what in the long term, if we take this longer term approach, will be what is valuable in ensuring that it has influence on the ground. And drawing on the evidence in the work of especially international relations theorists and political theorists, I would argue that the step of rejection which you see from the government is only one step and a necessary step in the process towards ultimately having what we might see as compliance or some sort of greater influence of the declaration. And we can see, I think, that Aotearoa New Zealand, that we're on this trajectory to some extent, and we see more I guess, traction in the legal domain than we do in the political domain, and that's what I want to focus on with looking at some cases in the Supreme Court, our highest court, where the declaration has been used and has been considered influential, if not the deciding factor. Also want to mention the use of the declaration in the Waitangi Tribunal, and as we've seen just this past week, or the past couple of weeks, the influence of ongoing, persistent and consistent censure of Aotearoa with respect to the declaration. So, for example, and you might have heard of the conclusions made with respect to Ihi Matau, an area of land in Auckland that has been designated for development, and this was an issue taken to the Committee on the Elimination of Racial Discrimination recently, that the UN committee, asked New Zealand to consider again the designation in light of the treaty, but also the declaration. So it is impossible, I guess, for the government to ignore the declaration because of this persistent censure. And then really want to enhance this thesis again, I think, picking up on Peter's comments about the need for us to enhance the declaration's legitimacy by using it, by putting it before the courts, by putting it before tribunals, by putting it before commissions, by having fora such as this, by making sure that our MPs and our political leaders know about the declaration, see it as a standard, that it's up to us to push it, and hopefully then, as Peter Sharples mentioned, that we can use it, for example, in advancing the need to protect and ensure that our children are speaking mōreo. So, as mentioned, the political influence has not been that so great with respect to particularly the National Party. This is seen explicitly in a number of ways, but also in a letter from Margaret Mutu, or to Margaret Mutu, in response to a question of hers as to whether the declaration should be influential and referred to in treaty settlements. And the response was, the declaration will not be referred to in treaty settlements. And that is quite recent, so it shows that there is a level of resistance remaining, despite New Zealand's support for the declaration, to the declaration. So, but however, we still see it raised in political debates and raised by Māori. Turning to the legal status, the legal status of the declaration is formally that it's not binding as a matter of international or domestic law. But as we know, and as our Supreme Court has pointed out, the rights in the declaration mirror many of the human rights that are binding in international law. It has a good degree of political influence and clout as a General Assembly resolution by the highest and largest multilateral body in the UN, been adopted by that after more than 20 years of elaboration. Adopted by the vast majority of states, and those 4 states, as mentioned, who did not support it on adoption in 2007, by 2011 all 4, which included Aotearoa New Zealand, had expressed their support for it. There is also the question as to whether the declaration is something called customary international law. Now, customary international law is important from sort of formal legal perspective, because if something is customary international law, it is then binding as a matter of domestic law and of international law. Certainly we see a number of scholars, including we've heard mention of Professor James Anaya, mention that it, or advance the argument that it is indeed customary international law. And I think this is something that we, when I get to talking about how we should engage with the declaration, should be arguing before our courts and in the political domain as well. What I'm really saying, though, is that while the legal bindingness matters, what is more important is what I call the legitimacy. So this is, again, drawing on scholarship before me, but really tries to capture that that legitimacy is this quality in international norms that leads states to obey them even when it might not be in their interest to do so, and despite the lack of international sovereign or sanction. It is true, and much empirical research has suggested that the influence or compliance with human rights does not depend on the legal bindingness on the norms, but however other factors, the influence, for example, of these norms, the way that they are embedded in the political and legal landscape, not so much this legal binding force. So this is, I guess, something that I'm trying to capture here. I don't want to dwell too much on 2 sources of legitimacy, which I do think are relevant, but perhaps I want to focus more on the value of engaging with norms. But I see that legitimacy comes from the processes from which these rights spring, the justice and substance, or what I call the substance legitimacy, and finally, as mentioned, what I'd like to focus on is the ongoing engagement with norms, the sheer use of these norms, that is what enhances the legitimacy from my perspective. As I mentioned, I do not want to dwell on this too much, but certainly procedural legitimacy goes back to the value, as mentioned, of the processes that led to these norms. And I would argue that there is a high degree of legitimacy, and this is, you'll see this referred to when legal and other political bodies refer to the declaration as a result of the participation over decades, literally, participation of Indigenous over decades in UN negotiations. The coming together, I guess, of Indigenous views wasn't a perfect process, but certainly the fact that Indigenous peoples influence the content of the declaration. I do say that I do think that while those Indigenous peoples and representatives who are participating in the declaration, I think most, if not all, think the declaration could go further, could say more, and Moana mentioned the question around self-determination as well. But equally, the declaration I don't think would have been adopted unless it had the support of the vast majority of Indigenous peoples. So that's where I think a lot of process or procedural legitimacy comes in. The others I won't mention so much here. On the substance legitimacy, that's really focusing on the fairness that is inherent in the norms. So if you read closely the declaration, you'll see in there the right to self-determination, rights to lands, territories and resources, significant and strong cultural rights, for example, to rights to political participation, to free, prior, informed consent, the need to acquire Indigenous peoples' free, prior, informed consent. So the argument about that is that these norms are ultimately a reflection of greater justice. To put that conversely, where a government doesn't respect Indigenous people's self-determination, rights to lands, territories and resources, the outcome is unjust. But the fact that there are these rights, the substance of these norms, is ultimately about justice and enhances their legitimacy. There are questions, as you can see on that slide, about what I call the determinacy and coherence of the norms. So the determinacy is about working out what exactly the norm means in practice. But I think a level of, indeterminacy in the norms is very normal in international agreements where you have to have norms that apply globally into various different situations. So you have to take context into account and how they're determined. But it's this that I would like to focus on, and that's that the legitimacy of norms and their influence and states' compliance with those norms can grow when states are sometimes involuntarily forced to engage with those norms. And that over time it becomes natural to see compliance as important, to see these norms as setting the right standards against which one should assess oneself and against which one should apply. I don't think that we are there now, but I think through this process of engagement we can stimulate that process over time. So, thinking about how how we engage and what institutions and bodies and individuals, us as people and as peoples, engage with these norms, we build a norm, what I call a norm infrastructure. So we build, a framework, an institutional framework around those norms, and the state cannot escape us as the norm entrepreneurs, if you like, or the infrastructure that we set around these norms. And some of this norm infrastructure, I think, comes from the constant censure that we have of New Zealand with respect to, not only censure, but also assessment of New Zealand against international norms. So that happens, as mentioned recently, with the Committee on the Elimination of Racial Discrimination, which is only one of multiple statements and comments from UN human rights bodies about New Zealand's compliance with international human rights with respect to Indigenous peoples, and increasingly specifically with the Declaration. As Tracy will talk about, the expert mechanism on the rights of Indigenous peoples mandate has just been expanded such that it will be taking a more active role in assessing states' actions with respect to the Declaration. Civil society, there are numerous and active players, both iwi players and also the wider NGO community that are constantly participating and reminding the government of the obligations under the Declaration. And that comes about in a myriad of ways, but including through shadow reports to UN bodies and including through advocacy at home and simply in other ways through protest. We see by using the Declaration in our courts and our commissions and the Waitangi Tribunal, as I'll talk about in a moment, we build, again, part of this fundamental backdrop which the government can't run away from and will constantly be questioned about the Declaration. Also submissions on law and policy formation, select committees and so on, and those are just some of the examples. So given my background as a lawyer, I thought I would focus on some of the examples in our Supreme Court and the way in which the Declaration has been used in our Supreme Court, our highest court of the land. And I want to focus on these 4 decisions. I'm not going to go too much into the facts, which is always dangerous because the context of these decisions is always very important to understand, but simply for time, I will gloss over the facts and just really focus on how the declaration was used, but happy to discuss further when we break. So many of you, and this is probably the most well-known of the cases, might know of the Takamori Case. This was a dispute about the burial place for Mr. Takamori. On the one hand, you had his wife and the executor saying that he should be buried in Christchurch where he had lived for the previous 20 years. On the other hand, his whānau, who came down from Kutarere, said that he should be buried in accordance with tikanga Māori in Kutarere. So the declaration was, so this became a contest in a legal setting between, I guess, the common law with respect to executor or personal representative rights to determine the burial place, and the argument by the whānau that this should be determined by tikanga Māori. And the argument that was raised was that tikanga Māori should be as part of the common law, and providing it satisfies some persons, I would say, ridiculous tests, it could be recognised as common law. But the declaration was used in argument by advocates to support the argument for the whānau, support for a tikanga Māori perspective. Now, in the Court of Appeal, we had some of the first references by especially Justices Glazebrook and Wild. In the Court of Appeal before then Chief Justice Shana Elias addressed it in the Supreme Court, and took quite a strong view on the declaration, citing that there is a presumption to interpret common law and also statutes consistently with international law, including in that implicitly the declaration. Talks about, under the declaration, the need to recognise the collective rights of Indigenous peoples, and then highlighting this point that a number of the articles in the declaration reflect what we see as in the human rights treaties that are binding on Aotearoa New Zealand, and relying again on some authority for that. In our Court of Appeal, Chief Justice Elias also picked up on the declaration for her argument, and saying that the preference for repatriation of the dead is recognised by the Declaration on the Rights of Indigenous Peoples as a matter of great moment. So again, using the declaration in a way to help it consider and address these particular issues raised in this case. But I would say that ultimately the case, I think, is unsatisfying and arguably falls well short of the declaration. And all judgments in this case, although coming at it in very different ways, they found for Ms. Clark that Mr. Takamori should be buried in Christchurch, contrary to tikanga Māori. Although the Chief Justice does say it's very finely balanced. But at least in part of the assessment and this case is somewhat authority for the idea that we shouldn't try and interpret the common law consistently with tikanga Māori, the declaration was of some influence there. The New Zealand Māori Council freshwater case, this was a case broadly a claim arguing that Māori rights to freshwater were protected by treaty principles, and there were treaty principles in the relevant legislation, and that those treaty principles and Māori rights to freshwater should prevent the sell-off of Crown assets in hydropower companies, particularly shares in those companies. Again, what I want to pick up on is that the New Zealand Māori Council argued that the right to redress in the declaration was relevant to support strong interpretation of treaty principles. So the case was fundamentally about the interpretation of treaty principles and whether they would protect this right in order to prevent the sell-off of these shares. Now, the Supreme Court in this case altogether said, we doubt if the declaration adds significantly to the principles of the treaty statutorily recognised, and the declaration provides some support for the view that those principles should be construed broadly. Now, while that sounds, the first sentence particularly sounds quite negative, I've wondered whether this means that the treaty then, in this interpretation, includes all the rights in the declaration. If the declaration doesn't add anything as the treaty as the courts understand it, then wide enough, to cover all the specific rights set out in the Declaration. And it is a thesis I've heard, and one will hear, is that the Declaration, particularly from Seredi Jury, that the Declaration sets out in more, I guess, explicit terms and concrete terms what treaty rights are. Also, the idea that we can use the Declaration to read out treaty principles to help us take a broad and generous view of treaty principles. So the next case is Paki number 2, another decision that reached our highest court. And in this case, which I think is one of potentially the, if you like, more progressive, unsettling for many ways still, I think, from a fundamental perspective, but arguably at least in New Zealand jurisprudence is a bit more progressive, is this finding that tikanga Māori interests in riverbeds are not automatically extinguished by transfer of adjoining dry land to the Crown. Now, this is fundamentally the same as the Ngāti Apa decision, the foreshore and seabed decision, saying that just because rights, according to common law or under statute, in dry land have been extinguished, that doesn't necessarily mean, or you can't implicitly then extinguish the proprietary interests in the wet land adjacent to the dry land. And in this case, so I think this case is more fundamentally potentially consistent with the Declaration, although you've got to remember that it's not undermining or questioning the extinguishment in the first place of the dry land. So you've got to bear that fundamental issue aside. But it recognises that Māori land rights cannot be extinguished by implication, and rejected the application of the common law with respect to Māori, or the introduction of common law with respect to Māori rights in wet areas of land on the basis that tikanga was there and tikanga regulated those rights in the land. So the Declaration again was cited with respect to the Declaration's articles on redress. I haven't actually really understood this, but a comment I think in Justice Glazebrook's decision that the need for more research on land transactions in tikanga, citing the Declaration in that context. So the final case is the most recent one, and that is in Wakatu. You might have heard about this case. It was the first time in which our Supreme Court has recognised that the Crown owes fiduciary duties with respect to historic land transactions. It's a particular case relying on a particular set of facts, and there are questions about fiduciary, this doctrine of fiduciary duty, and whether it is a good thing from a Māori perspective to recognise fiduciary duties. But at least in this case, there is some promise of actual Crown accountability, I think. So the appellants used the Declaration in a number of ways in their submissions, talking about the role of courts in protecting legal rights of Indigenous peoples. And that was particularly important in this case because there was also a treaty settlement relevant to the particular area of land. So the argument that the appellants were raising was, okay, well, you might have a political settlement, but we also have to uphold legal rights. And the Declaration was used in support of that. It was that the Declaration came in not so much in the substance of the fiduciary duties, but particularly with recognising the standing of Wakatu Incorporation. Because Wakatu Incorporation did not, as a result of history really, but all the members of Wakatu weren't necessarily all the ancestors of the children, I guess, of the former customary owners. Some had lost their interests and some people had been brought in. There was a question about whether Wakatu Incorporation had standing to bring this case. And the Chief Justice and Glazebrook both said that Wakatu did have standing because there needed to be some flexibility in understanding who represents Māori. And so using the Declaration to recognise the standing of Wakatu Incorporation. Finally, the Declaration and the Waitangi Tribunal. The Waitangi Tribunal has been far more open to the use of the Declaration all the way through, really, since its adoption. In its fundamental approach, obviously, the Waitangi Tribunal's objective is to assess Crown action against the principles of the Treaty of Waitangi. but it is using the declaration as a support for its interpretation of the principles of the Treaty of Waitangi for, as was referred to earlier, this in the respect to the New Zealand Māori Council case, as a way to flesh out what the declaration, what the treaty might mean in practice, and with respect to concrete allegations of Crown omissions and failures with respect to treaty principles. So just one particular report, and that's Y2417. This involved the New Zealand Māori Council's claim that Māori, not the Crown, should determine amendments to Māori institutions. The Crown was proposing to amend legislation around the New Zealand Māori Council, and the New Zealand Māori Council basically said, well, it's not for you to determine what we look like as a Māori institution, it's up to us, or up to Māori to determine that. And were successful in the tribunal on that claim. What was significant from the perspective of the declaration was that the declaration was used throughout that report and throughout the arguments from the New Zealand Māori Council. So it was found to be relevant to the interpretation of the treaty, that it restates human rights, relied on the judgments of the Court of Appeal and Supreme Court to say, well, the declaration has some support in our courts. It grouped its analysis of the various different potential breaches of treaty principles and coupled those treaty principles with particular articles of the declaration. So it was matching up treaty principles with particular articles of the declaration. So quite explicitly drawing the two together. And was also mentioned the concern that it would have about international censure, human rights censure of the Waitangi Tribunal, if it did not take an approach that was at least consistent with human rights obligations and the declaration. Excuse me. So finally, as mentioned at the start, we have this ongoing oversight of New Zealand's compliance with respect to human rights more broadly, and increasingly with the declaration specifically. So we see this, and Tracy's going to pick up on a number of these. We see through the expert mechanism on the rights of Indigenous peoples and the work, especially of the iwi Chair's International Monitoring Mechanism, which is a group that assesses, authorised by the iwi Chairs, that assesses compliance against the declaration and presents each year to the expert mechanism its findings. That, coupled with the expansion of the mandate, as mentioned, of the expert mechanism, with a greater role that it can now have in the domestic arena, I think New Zealand won't be able to run away from that. With the Human Rights Council, now that's the largest. Well, it's the main, rather than the largest, the main multilateral state body dealing with human rights. And it has its own process which every 4 or 5 years will require states to present their human rights record, and will assess in the Human Rights Council the state's human rights record. What's interesting about that is it's other states assessing, for example, in the case of New Zealand, against their human rights record. And in those reports from the Human Rights Council, the findings of the Human Rights Council, New Zealand is frequently called up with respect to its compliance with human rights norms with respect to Indigenous. We know the UN Special Rapporteur on the Rights of Indigenous Peoples, who's various special rapporteurs. We've had 2 visits in Aotearoa, New Zealand, but one especially after the foreshore and seabed debacle, and then one more recently from Professor Anaya, that highlight the need for fundamental change to New Zealand's constitution in light of the declaration and international obligations. And of course, we've got the Permanent Forum on Indigenous Issues, where we've had a number of Māori attend and participate and raise these issues in New Zealand's compliance again. And as mentioned, with Ihi Mātou just recently, the call on the New Zealand government to consider the designation of their land in light of the treaty and also the declaration. So my conclusion is, despite the reluctance on the part of the government in the political domain, as we saw earlier, those comments from Chris Finlayson, the declaration is informing and influencing New Zealand, particularly in legal fora. We need to work, however, on the political fora, although it's hard to, I think, divorce the two completely, because the government can't avoid obviously, the legal obligations and the use of the declaration by our courts. But I would see this use in legal fora, and both domestically and internationally, as enhancing the legitimacy of the declaration and ultimately in this long process towards trying to achieve some sort of compliance with the declaration or greater influence of the declaration. This is definitely an important part of the process. And how can we collectively support this? By using the declaration. That we should all use it in our arguments, be it in our protests, in our written work as academics, in our legal submissions, in treaty settlements, in UN fora, that we should be constantly using this declaration before the Human Rights Commission and the Law Commission if it's got a project that's got something to do with the declaration. That it's incumbent on all of us to become these sort of norm entrepreneurs and enhance the legitimacy of the declaration in the process. So, nō reira, tēnā koutou katoa. Kia ora.